What's up, guys? It's your boy, the Badwolf, here to bring you some more information of goodies. Welcome, loves, lovetts, Whovians, Elohim, Elos, light workers, good-hearted people, all the above. We are on the Badwolf Entertainment show. All right, so what are we talking about today? 7 secrets your prosecutor doesn't want you to know. Now, this one is more so for the DUI, okay? So, driving under the influence. Now, we don't condone any of that here. But we are going to give a little bit of help out there for those people who have been looking for said things. Let me just queue up something here. Okay. All right. As always, guys, don't forget to support the Badwolf. Any donations you guys can provide would be great. Those have been pretty dry lately, but that's okay because we have a number of people who have joined the Badwolf private group, the Wolf Pack, which can be found on the YouTube channel. Clicking the join button. Any pack that you join, any level, will get you information that everybody shares. Okay? And so, watching those videos will give you access to the secret Telegram group. Otherwise, the standard one is Badwolf Unincorporated, open to the public-ish. All right, so let's get the ball rolling. All right, so one, if every defendant insisted on their constitutional rights or right to go to trial, the prosecutor handling the DUI cases would be in court all day long. Okay, so if you were to do that, you're going to have a whole lot more protections up there than the lower courts because you're going to be looking at, let me say this correctly. If you enact your constitutional right to go to trial, then other people there have to judge you versus just the judge, okay? And there's a lot more leeway and sympathy that can go along with convincing 12 people than one who might be against you for whatever the reasons are. 2, now more than ever, the minimum mandatory sentence for a DUI offenses are so severe, a DUI defendant has little to risk by taking their DUI case to trial. Okay? Like I said, typically, especially like in the Midwest, where lots of people, were raised on drinking. Everybody drinks. Everybody drinks. So if you're in a township where not that it's dry and you were busted, I wouldn't try it. But if you go to trial, and they're not going to want you to go to trial. They're going to want to be able to handle it. It's quicker, it's sweeter, they make more money, blah, blah, blah. And then they have all the control and power. Well, when you go to a trial, you have a number of people who will probably have had their own DUIs or be sympathetic because they know what the area is like. Whatever, especially if you didn't hurt somebody. It's a victimless crime in all actuality, though it could be a concern for public safety. But let's move on, shall we? Okay, the state attorney does not want to be there any more than you do, okay? So no attorney working for the state office, the SAO, wants a career in prosecuting misdemeanor DUI cases in criminal court day after day, blah, 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 blah. They would rather be doing high-profile felony cases than covering traffic stuff. Okay, let's just be real. So the senior assistant state attorneys try to get assignments to the fastest judges so they can be done with the court each day as soon as possible. Okay, so the assistant state attorney is never fully prepared. They have too many cases to juggle each and every day. Okay, So let's say in Florida, the state attorneys do not review traffic cases ahead of time because they are overloaded with case files. They barely review the DUI cases before they even go to court. So don't be shocked if I tell you that it's impossible for you to contact a particular assistant state attorney with knowledge about your case before the court case is there, or to dismiss your case, because the assistant state attorney rarely go over these cases before court. In fact, most DUI cases are not assigned to the designated assistant state attorney until the last possible minute. Okay? Which also you can contact your district attorney and try to work out something with them. Anything that you can use with you, you're a good person, you're going through a rough time, family problems, whatever, that will help. Tell them you want to get this over with as soon as possible. If we can compromise, if not, then I want to take it to trial. Okay? The arresting police officer is unprepared or fails to show up. So, it's common for a police officer to have anywhere between 25 to 30 DUI cases and other things going on one date, in addition to dozens of other traffic tickets where he has to appear. Okay? Without fail, the arresting DUI officer has no recollection of your DUI arrest because he's made hundreds of arrests before yours. So in other words, what's really going on here is if you push them to go to trial, everybody does, it'll clog up the system, which will then make them want to just drop a lot of stuff or to speed through and try to give you the minimum because they want to make as much money as quickly as possible. So the quickest way for them to do it is you taking a plea, which perfects the jurisdiction, and now they have you grabbing your ankles at the Christmas party in the back room. So this happens over and over again with the police officer, having him on the witness stand. He will then go over his notes, okay, because he's not going to remember every single thing. Think about it. These guys do this every day. Boom, 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 boom. You think they remember just you? Remember everything? It's like being at a nightclub all night and talking to 20 different chicks. You're not going to remember all of their name and whatever else. So they have their little notes. They kind of brief over that. You kind of get where I'm going with this. So a seasoned DUI defense lawyer will object to an officer reading from his notes. And after the objection is sustained by the judge, it becomes obvious that this officer has no independent recollection of your arrest because the answers to the cross-examination questions will be something like, I don't recall, or I'm not sure, I think you did, it's possible. He has to be exact. If he's not exact and it matches his exact record at the time, which is why they usually want to go over these things right before, or just not even show up and appear. Now, if they don't show up and appear, you can move to dismiss because they're not there. If they're your main witness, okay? So you are the arresting officer and you're the main witness. Some would argue there might be a conflict of interest there. You're arresting me and you're the witness. What are you? Okay? And here's the thing. If the prosecutor is speaking on behalf of the cop, well, that's even better because then that's hearsay, and hearsay is not admissible in court. So you're going to want to push to a motion to dismiss because the prosecutor has no firsthand knowledge of the events. It wasn't him. He didn't see it. He's reading. That's not you. You have no firsthand account. Okay? So you can understand that why these guys arrest hundreds of people, literally. More good than bad, we'll just say, I'm sure. But anyway, he can't be expected to remember each and every DUI, every exact aspect and whatever else of the scenario. Okay? So next, the assistant state attorneys know very little about the so-called science behind the field sobriety test. Now, one of the things, too, is that the attorneys, they don't necessarily take the course and be licensed in field sobriety tests, okay, or licensed or have a certification, and you'd be surprised. Some of those cops may not have it either, all right? Depends on your state, so once again, this is all education and entertainment purpose only. You have to know. These are just tidbits that you guys can help use in certain scenarios, similar to. Standardized field sobriety tests, roadside tests, is not something taught in any law school, okay? It's not taught in any driver's education class, and it's not found in your driver's handbook. Okay? So, in all actuality, I wonder if that could be, well, you're not supposed to be doing it anyway, but I don't know. I'll have to think about that. There's some other things in there you could probably challenge. Anyway, so they are not part of the Florida driver's license exam. Now, here's what's interesting. Screw it. I'll just throw you my thoughts. If the sobriety test and what it is not provided by your state in the driving program, could one argue, then how are you going to make me take a test that I'm not prepared for? Hear me out. Shouldn't be driving under the influence anyway, hands down. But legally and lawfully, how can you subject me to a test that I have no idea what you're going to do, what you're looking for? I think I have the right to know my rights before I even do it. That is a hell of an argument. I don't think I've ever heard anybody use that one before. Interesting. Because that'd be like an officer saying, here, you shouldn't be out here hunting. Take this gun and blast 3 shots right into the center, 2 into the outer, and 1 perfectly in the middle. Wait, what? Okay. And then I don't do it, and then he arrests me because, I couldn't do this test. Just a thought. All right. So, okay, so this is not found in your handbooks for an examination, so you're not even familiar with it, okay? So because they're not part of your driver's license exam, you are not required to do the heel-toe walk turnaround exercise. Now, you have to see what's required in your state. This may not apply to all states. I'm just saying in general. And even states where this applies, this could be something where you can be challenged on. Okay? So, or the one-legged stand. 13 states already refuse to allow horizontal gaze or the nystagmus test, the HGN test, which is where you stutter step your eyes. They try to make you, okay, like that too. How do you know that I don't have the condition where I could possibly have seizures from you putting the light in my eye? Okay. They don't. Or they want to say you've got slurred speech or you're stammering. How do you know that's not my normal talk? These are all techniques and tricks that people can use in their defenses. Okay? Once again, we do not condone anybody operating under the influence whatsoever. Whether this, that. All right. So, these tests are typically unreliable in measuring any level of intoxication. I can tell you right now, I've taken many of these tests. At the station, on the side of the road, whatever, let's be honest. And 9 times out of 10, even at the station, I've passed. Why? Because some people can handle their liquor better than others. Now, that doesn't mean that just because you can, you should. But what it means is that the same tests that you give to somebody who's athletic, somebody heavier set may not be able to do. Whereas I can do some of this stuff, probably educational information only, over the limit, and somebody completely sober can't do them. Okay? So it's a guesstimation, and it's inaccurate, it's unreliable. Now, somebody who's clearly, even that could be a medical condition or a genetic condition. But in general, 9 times out of 10, if you're like, or one of the ladies, hey, if you just look at can you let me off my ticket? Or you open the car door and you fall on the ground, probably over the limit. Probably endangering safety, and that should be dealt with. Okay, especially in this day and age, we have Uber. Okay, so I don't recommend operating the vehicle buzzed. Know thyself, but in general, if you feel like, I should be good. I'm only a couple blocks, but you know you're drunk. Just get an Uber. Tell the bartender, hey, I think I've been overserved. Usually they will get you a cab. Okay? Or you can just Uber. It's not worth it. All right? You're endangering your life and other people's lives and friends and family, so don't do it. Okay? I understand nobody's perfect, but there's definitely some people out there who are high and this, that, and the other. And hey, if it was a straight shot home and you want to risk your own life, have at it. Find all the poles and whatever you want to find, or blah, blah, blah. But in general, don't endanger other people's lives and family members. So, all right. So now these SFSTS tests are not even considered actual tests by scientists. They are not recognized in the scientific community or the medical community as having any reliability in predicting intoxication. They're actually exercises that are designed for failure. A thorough and complete knowledge of these field sobriety tests would actually hurt the prosecutor's DUI cases. In fact, it would stop them from making the argument that the results of these tests, exercises, should be given more weight and credibility than they deserve. All right? I just told you guys why. So, the arresting DUI task force officer did not follow proper procedures when conducting the field sobriety exercises. When a police officer receives proper training about field sobriety exercise, he learns the proper standards and procedures used according to the National Highway and Traffic Safety Administration, NHTSA. However, for example, on the follow the pen, or the HGN, horizontal gaze nystagmus test, the manual says that if the suspect moves his head during the exercise, the officer should use his flashlight or his free hand as a chin rest for the suspect. I don't want you touching me. You have no right to touch me. I haven't done anything. But okay. In my experiences as well, not my experience, but we'll just say this particular person, so what the officer will usually do is they'll lie and say you were slurring, you were swaying side to side, your feet were unsteady, involuntary movements. Some people have those. I'm not even drinking right now, and I move all the time. It's just how I do. Most people do. Almost nobody's like, yes, go on with the test. I mean, even then, look, I just move my head. So what? I have to just move my eyes? You know how many few people actually move their eyes just like this all the time? Most people use their whole head. Okay, and even now, it just hurt my eye muscles to do that. So that's not even a legitimate test. All right, but I get what they're trying to do. They're just trying to get an indication if they can get probable cause. Okay. Without a reasonable doubt, I'm pretty sure he is, so I'm going to take the chance on it. Okay. So the manual also indicates that the walk and turn and the one-legged stand exercise should not be done if the suspect is more than 50 pounds overweight or has physical limitations that could affect his balance. The manual also states that the walk and turn exercise requires a line that the suspect can see, which is almost always ignored by the testing officer. So I would even challenge the officer there was no line there for me to walk. And what size is the line? Does the manual tell you how many inches and how long it has to be? There has to be a standardized measurement for this, which we all know there isn't. Because then the officer would have to take out some chalk, draw it perfectly, have you wait, and then you walk, or lay down a line for you to walk on. So it's not standardized. Okay? So I'm trying to show you there are some things. Now, don't get me wrong, I'm very happy that there are some awesome officers out there who are taking people off the street who are potentially endangering or have endangered or would have endangered people's loved ones, including my own and whoever else. So thank you for that. But there are some people who have been railroaded so that these officers can make quotas, which should be illegal, everywhere, and get a little pat on the head and a little watch after 20 years, making a ton of money for their for-profit corporation and the people above them. But there are some good cops out there, so thank you guys directly and only for your service and your work. That's it, guys. So a couple more videos, and we've got more howling mad stuff from your favorite non-belligerent, non-combatant treaty with the United States. God bless all Americans, and I will talk to you later. Pew.